Blava & Co Solicitors, committed to excellence.
Hello, my name is Gemma Neath and I'm a solicitor in the Family Department at Blava & Co. One of the most difficult issues that families face following the breakdown of a relationship is when one parent wants to move abroad with their child or children. If parents can't agree this between themselves, the parent wanting to take the child away will need to make an application to the court. Now, just to be clear, I'm talking here about wanting to move away permanently and not just for the purpose of a holiday. Such applications, often referred to as relocation cases, most often arise from one of the following scenarios. 1. The applicant might wish to return home if they're originally from another country, for example Australia. 2. The applicant might wish to take up life elsewhere with a new partner. Or 3. The applicant has been offered a job in another country. Now, there's usually no right or wrong answer in these cases. Instead, there is a dilemma and a very, very difficult decision for a family judge to make. For ease, I'm going to refer to the mother as the parent who wants to take the child abroad and the father as the left-behind parent. Payne and Payne is the leading case in this area of law. The case involved a mother wanting to take her child to New Zealand. This case laid down the following test. Firstly, is the mother's application genuine in the sense that it is not motivated by some selfish desire to exclude the father from the child's life? Second, is the mother's application realistic? Namely, is it founded on practical proposals which have been well researched and well investigated? For example, in respect of job prospects, health, education, accommodation, and contact proposals for the left-behind parent. If the mother fails either of these two tests, then her application to move away is refused. But if the mother passes, then the following issues are looked into. A careful appraisal of the reasons for the father's opposition. Is it motivated by genuine concern for the future of the child's welfare? What would be the extent of the detriment to him and his future relationship with the child? And to what extent would this be offset by extension of the child's relationship with the maternal family in the homeland? The court will also look at the impact of refusal on the mother. And finally, and most importantly, the welfare of the child is always paramount. So when making such an application, the following points need to be remembered. There is no presumption created in favour of the mother. The reasonable prospects of the mother wanting to move abroad will carry a great deal of weight. There has to be a genuine motivation for the move, not an intention to frustrate the contact between the child and the father. The effect on the mother if her application to move is refused is very important. The effect on the child of the denial of contact with the father also needs to be balanced. And the opportunity for continuing contact between the child and the left-behind father is crucial. At the heart of the problem in these sorts of cases lies the tension between dislocation of contact with the father and the reasonable desire of the mother to relocate. The case of Payne has attracted much criticism due to it placing, some might say, too much weight on the emotional and psychological well-being of the mother. But nonetheless, it does still remain good law. Since the case of Payne, there have been a number of cases in this area, and by no means have all of the mother's applications been successful. The key to remember is that each case is fact-specific, and unfortunately, therefore, it can be very difficult to predict the outcome. At Blava & Co Solicitors, we have experienced staff in this area of law to handle such matters. So if you are wanting to make an application to move permanently abroad with your child, or indeed you find yourself having to defend such an application, please do contact us. Depending on your financial circumstances, you might be eligible for public funding, previously known as legal aid, but where this is not available for whatever reason, we can represent you on a privately funded basis, either at an hourly rate or on a fixed fee basis. With 7 offices in and around London, Hertfordshire and Surrey, we can offer an appointment at one of the offices which is most convenient for you. So do please visit us at www.legalblavo.co.uk or telephone us on 0207 025 2020. We look forward to hearing from you.